Good afternoon. Welcome everyone to our 4th annual Osgoode's Internationally Trained Lawyers Day. My name is Megan Thomas and I'm the Director of Professional Graduate and International Programs for Osgoode Professional Development. And I've been working on internationally trained lawyer programs since 2013 here at Osgoode Professional Development, and it's my great pleasure to be able to be here and welcome you for this event. We started Internationally Trained Lawyers Day in 2015 to celebrate the launch of our online NCA exam prep program and also to celebrate the growth of both our internationally trained lawyer programs at Osgoode as well as the growth of the community of internationally trained lawyers in Toronto and Ontario and beyond in Canada. This day is really about 3 things. The first is celebrating the really deep pool of talent of internationally trained lawyers and all they contribute to Canada. Their talents, their contribution to diversity, the increasing reflection of different communities in the legal community here in Ontario and in Toronto. The second reason for this day is to provide information about regulatory processes, about career opportunities, about educational opportunities, tips and best practices from others who've gone through the process before. Because we know and we continue to be reminded every year when we see new groups of internationally trained lawyers coming into the community that it's not always easy to find this information on your own. So we're here to provide a source for that information. And the third reason is to create a community of internationally trained lawyers that is broader than just the students and alumni of Osgoode Professional Development, but also includes those who are out there already practicing here in Canada, who are pursuing rewarding non-practicing opportunities, as well as people who are just at the beginning of the journey or not sure yet whether they want to become licensed here and just want that community to help them make those decisions. So we've been building on all of those reasons for the last 3 years, and we're happy to be doing it again this year. Next, it's really important for me to thank a lot of people who contribute to putting this day together. First, I'd like to thank our leadership at Osgoode, including our Dean at Osgoode Hall Law School and our Executive Director at Osgoode Professional Development for being really supportive of the programs that we run for internationally trained lawyers here at Osgoode. We have the largest program in Canada, and we couldn't do it without that institutional support. Secondly, I need to thank our sponsor, Jones & Co. You're going to hear Paul Jones on one of our career panels later today. He's been a real champion of internationally trained talent and has offered internships to a number of our students over the years and has quite a successful international practice here in Toronto. Thirdly, our amazing speakers who've come to contribute to the day, and you will have seen our agenda online, and I'm going to talk a little bit more about that in a moment. We couldn't do this without all of the contributions that we get from regulators, from alumni, and others who come to speak. Next, the team here at Osgoode PD who helps put this event together. It's a large team, and I'm just going to say a special thank you to the people who've been on our organizing committee. Michael Tam, who's a program lawyer, and you'll be meeting him later in some of our sessions because we'll be splitting up moderating duties. Luke Heald, who's our manager of international programs. Andrea Chow in marketing, Renee Abraham, who is our operations manager, and Rohini Parshad, who is an international programs assistant in our international business law program. Next are volunteers, most of whom are current OPD students, and you will have met them when you checked in, and they've been spread all over campus welcoming people and making sure that those who aren't familiar with Osgoode and the York campus got here on time. So thank you very much to all of our volunteers. And finally, thank you all for coming and spending the day with us and enriching all of us. Whether you're here in person or whether you're watching our live stream, the first part of our session today is going to be live streamed on YouTube, so we have some virtual participants as well. York University, as part of events and many of the activities that take place here on campus, wants to acknowledge its presence on the traditional territory of many Indigenous nations. The area known as Takaranto has been taken care of by the Anishinaabe Nation, the Haudenosaunee Confederacy, the Huron-Wendat, and the Métis. It's now home to many Indigenous peoples. We acknowledge the current treaty holders, the Mississaugas of the New Credit First Nation. This territory is subject to the Dish with One Spoon Wampum Belt Covenant, an agreement to peaceably share and care for the Great Lakes region. And so we take that spirit in sharing with each other in this event today. So next, I'm just going to pass to some housekeeping on our agenda for today. We have a number of sessions this afternoon, and the first session, which is going to begin at 1:15, which is in 5 minutes, you have two options. And I hope many of you will have turned your minds already to which session you'd like to attend. If you stay here in this room, you'll hear from Malcolm Mercer on the NCA accreditation process. So those of you who are a little bit closer to the beginning of the process, perhaps you are not in your NCA assessment period yet, you haven't started your exams, or you have some questions about completing that process, may want to stay here. We also are going to have a really excellent career panel on finding your strengths. So how do you define your value, your place in the market as an internationally trained lawyer? And that's going to be just across the hall in room 1003. So that's just on the other side of the door on the same floor. So that's going to be our 1:15 session. We'll then reconvene in here at 2:15 when we'll hear from a panel from the Law Society of Ontario about the licensing process. We're then going to take a break with some snacks at 3:15. At 3:30, we'll be here again for the Law Practice Program information session with Andre Bacchus. We are then going to have a presentation I'm particularly excited about that features our wellness counselor at Osgoode PD, Eva Keithley. We know that the NCA process can be stressful, and many people are balancing going through accreditation and licensing with other responsibilities. There can be feelings of isolation or being overwhelmed, and so Eva is really focused on practical strategies that can help you through that process. We'll then take another quick break at 4:45, and we're then going to have a panel of alumni on career paths, and Paul Jones will be speaking at that session, who's our sponsor. And then finally, we're going to have our keynote at 6 o'clock from Hadia Roderique, followed by a great networking reception with wonderful food and opportunities for conversation with those you maybe haven't had a chance to chat with during the day. And that will be over in the Hellawell Center, which is just down the hall. So I hope you're all as excited or more about what we're going to do today as I am, and I look forward to having an opportunity to chat with many of you later on today. And for now, we're going to give you about 3 minutes to either get yourself comfortable and settled here or move across the hallway for our career counseling panel. this will be the NCA process. So if you are just at the process, okay, so this is a good spot for you because this is going to talk about how the accreditation process works. Okay. Fantastic. So let's get started. I'm really pleased to have with us today Malcolm Mercer, who is a partner and general counsel with McCarthy Tétrault, as well as a bencher of the Law Society of Ontario, but he's here today in his capacity as a member of the National Committee on Accreditation. I want to send warm greetings from the executive director of the NCA, Deborah Wolf. She's at a competing event today, so wasn't able to attend, but she's sent a wonderful representative of the NCA to be here and present for us. And Malcolm is a really well-respected member of the profession, is quite involved in dialogues about accreditation and licensing. He's written for SLAW and other publications and has received multiple awards for his dedication to the legal profession. So I'm going to invite Malcolm to come up. Thank you very much. And I just want to mention we will take some questions. I'll leave it to Malcolm whether he wishes to do that at the end or during. And I want to invite anyone who is watching us on the webcast to pose a question through Twitter using the hashtag OITLD18 hashtag, and I'll pass on the question. Thank you, Malcolm.
Thanks. So let me start by saying that you would have been better off to have Deborah, because she's the one who runs the place and really understands it in depth. As you can tell by the amount of hair and the color of my hair, I'm an older lawyer. That's a disadvantage because Deborah makes things work. I'm part of the policy committee that supervises and deals with appeals, but not so much the day-to-day. I thought I'd start, though, by telling you something that I don't know that you have any sense of, and I'm not sure that it'll be of interest, but I think it's kind of interesting to put all of this in context. If you looked at Ontario, and Ontario is where I have the stats to talk about, if you looked at the period from about 1970 to about 2000, there were about 1,000 to 1,200 candidates for licensing that came.
Because we're live streaming, could you please use the microphone?
I'm told I have to talk into the microphone. I'm not nearly that orderly. So, as I said, if you go back from about 1970, which is before my time, to about 2000, you're dealing with about 30 years. If you looked at Ontario, there'd be about 1,000 to about 1,100 people coming into licensing each year. And they came into licensing because that's how many law school spots there were in Ontario. There were some that came from other Canadian law schools, and some of the Ontario graduates went outside of Ontario. But as of 2002, there were about 1,100, 1,200 in total, and 100 of those were foreign-trained students. About 100 of those came through the NCA. So if you think about that, and you think about really 30 years of really constant volume, in the 15 or 18 years that followed, we went through very substantial change. And we've gone through substantial change in three ways. The first is that Ontario law schools, for the first time in a generation, increased the number of first-year places that they have. Osgoode did, Queen's did, Ottawa did, Windsor did. And there were a significant number, I'm guessing around 300, but it might be 400. As well, we have now coming into Ontario from foreign trained students such as you, numbers such that we've gone from about 1,200 in total to about 2,200, 2,300 in total. And what's interesting about the foreign trained, foreign schooled students is that it's a real mix of Canadians going overseas or to other countries, not necessarily across the sea, for training, and as well substantially increased immigration to Canada from foreign trained people. And so we have this radical change over the past 15 years, 18 years. And it's interesting. It's interesting because the complexion of those seeking licensing in Ontario has changed in terms of country of origin, in terms of custom, in terms of ethnicity, in terms of background. And it shows that the demand to become a lawyer has increased because it's enough to increase the number of law school spots in Ontario, and it's enough to increase the number of people who want to go to England, to Australia, to the United States to be trained as well. That's created opportunities and it's created challenges. It's created challenges because infrastructure, articling being part of our infrastructure, had to keep up, and it didn't, with very rapid rates of change. And so the reason I give you this context is for you, the entire world is the last few years, but it's helpful a bit to understand the broader context. It certainly is if you're trying to understand what to do about all this as a policymaker, both in the law school and in the NCA. So with that historic context, let me tell you what the NCA is a bit about. As you probably know, in Canada, constitutionally, the regulation of professions is a matter of provincial responsibility, not a matter of federal responsibility. And the way the provinces regulate the professions in the case of law is they, in effect, delegate responsibility to the law societies. And what do the law societies do? The law societies are responsible for determining who can practice as a lawyer or a paralegal. In Ontario, whether or not anybody else can provide legal services. And so we're responsible not for governing the universities. We have no authority over the universities, and they tell us that quite regularly. But we do have responsibility for determining what law school diplomas we accept for licensing purposes. And mostly that's not controversial, but sometimes it is. So the law societies have a role in saying to the law schools, if we're going to recognize your degree, this is what, as a minimum, has to be in it. The law societies as well determine what training and examinations are required for domestically educated candidates after they've got a common law school degree from Canada. The NCA process is the equivalent, and I'll come to it, for people who come to the licensing process having received their education outside of Canada. Once you become a lawyer in each of the provinces, the Law Society then is responsible for a number of things, the most important of which is conduct. The Law Society sets out how lawyers must conduct themselves, and lawyers can be disciplined, including losing their license, if they don't conduct themselves appropriately. Obviously, loss of license is the worst case, usually involving dishonesty, criminality, fraud. We also do other things. We run in Ontario an insurance program. It's an odd thing for a law society to do, you might think, but we think it's part of the way of telling people in Ontario, not just that you can train, not just that you can trust the training of a lawyer, not just that you can trust the conduct of a lawyer, but if the lawyer messes up, there's insurance available, compulsory insurance available to protect the clients of lawyers. Interestingly, in the United States, insurance is not mandatory and isn't common. I think that's important. We have a compensation fund as well, which deals with fraud. Our insurance program deals with errors and omissions. So what does the Law Society do? It does a range of things. What is most important for you is it decides how to deal with foreign trained people coming to become lawyers in the provinces here. And the Federation of Law Societies has no regulatory power. It is the voluntary association of the law societies across the country. And what we've done, because it makes sense to work together, is through the Federation we've created this National Committee on Accreditation, which is the way that each of the law societies in effect delegates their responsibility for licensing for people who don't get their degrees in Canada in the common law system. To give you a sense of what the professions look like, we've got about 120,000 lawyers across Canada. I think I heard this morning there are about 58,000 in Ontario, about 25,000 in private practice. We have notaries in Quebec. That's for those of you with a civil law background. The notaries in Quebec are out of the French civil system, and they are like solicitors in England, like those who do transactional work in the common law world, but they're a different profession. And in Ontario, we have 9,000 now licensed paralegals, and you can think of them as licensed advocates in tribunals and some of the lower courts. That's all they do, all they're allowed to do is advocacy work in small claims court, in landlord-tenant court, in a variety of different areas. Ontario is unique in Canada, having licensed paralegals, actually quite unusual in the world. There were about 2,000 of them a decade ago, and so you can see the rapid rate of increase. So as I've adverted to, what the NCA's job is, delegated in effect by the law societies, is to assess qualifications. And what is the assessment about? It's about legal education and professional experience. And we also have a sort of a side mission of dealing with Quebec civil law graduates. Because Quebec is civil law, the rest of Canada is common law. If you do your education in Quebec, you don't have a common law education necessarily. You can from McGill, but not from other universities. And so we provide, through the NCA, the route into the common law bar in Canada if you didn't go to a common law school in Canada. So I give you that overview not because I think it matters a ton to you, but you never know when you're trying to understand why something is. It's a bit helpful to have a context. It may sometimes help you understand why things are. That, of course, assumes things are rational, and they aren't always. So what does the NCA application, what does the NCA process look like? We have a flow chart. Deborah Wolf is an engineer. Deborah Wolf is not a lawyer. Deborah Wolf thinks in flow charts. I know this because I started as an engineer as well, and I can recognize it in Deborah. So Deborah starts in her slide with the application, and she notes that documentation is required, and I'll come back to that, and a fee is required as well. Once the a process whereby they have to write examinations and perhaps some school work in the Canadian law schools, but mostly it's examination work. Or they're directed to go and spend time at a Canadian law school, perhaps a degree, perhaps less than a full 3 years. The point of the examinations is to really create a bit of a compromise. We want to be able to admit and recognize people from around the world, and we are not able, it really wouldn't be possible, to assess all of the law schools around the world in any meaningful way. And so we assess countries, and we rely on the regulators in those countries for their assessments of the law schools. But we don't rely entirely because we don't want to do that. The compromise is rely on the foreign government, the foreign licensing regime, in substantial part, but as well we want to be able to know by examinations that there's some quality assurance that we can look at and be comforted by. So that's part of it. The other part of it is that we know that law schools, universities in other countries, not surprisingly, don't teach Canadian law for the most part. Some do, but most don't. And so we want to make sure that certain Canadian law courses are taught. So one of those two streams you go through, I expect everyone in their perfect world wants the exam stream and wants as few exams as they possibly can obtain. My perspective on this is that there are appeals where Deborah, as executive director, makes a decision and a candidate says, I don't agree with that. There are appeal panels through the year. I think it's 4 separate sessions. And one of my jobs is to sit with an appeal panel, there are 3 of us each time, and decide whether or not the appeal is merited, whether or not there should be fewer examinations, if going back to school was required, whether that was too much. So that's how I know about these things, and that's the role that I play. Once you get through step 4, step 5 is a certificate, and that's the desired outcome from the NCA. The desired outcome certificate of qualification, conceptually to the law societies, says to the law societies, you are equal to someone who graduated from an accredited Canadian law school with a degree. It puts you on the same footing for licensing purposes. The law societies can say, you know, we actually think you're a bit better than that. You've got some experience that we can take into account with respect to articling or otherwise, but it puts you, the certificate is to put you at least on even ground with the graduates of accredited law schools in Canada. So I'm not entirely sure why this slide exists. I think it's for those who prefer to read as opposed to see graphics. Near as I can tell, there isn't any difference, except there's slightly less information. So I'll pause. And now that I've paused, I'll go to the next slide. So Deborah has set out here, and these are her slides, which is why I'm able to do this. The first step, the application step. And first point is that the Federation of Law Societies website is the home for NCA information. It's easy to find it. It's got a .ca at the end of it. I keep going to flsc.com, which is confusing, but it's .ca. If you search Federation of Law Societies Canada, you'll get to the same place. We take care to do, or we try our best to make sure that there's transparency in this process. We want the policies, we want the process, we want the instructions to be transparent for people, because we think it's really important that the process be transparent and fair. So look, if you haven't already, for the instructions. Second point, bullet point, we of course trust you, but not entirely. Ronald Reagan, who was the American president in the early 1980s, referring to the Soviets and missiles, said trust but verify, which is what the second bullet is about. We require transcripts, and for those of you who are licensed in other jurisdictions, certificates of membership in the Law Society or the equivalent. And those have to be sent directly to the NCA. If you provide them, we can't be sure that they're real. And I hate to say it, and sometimes they weren't. It's useful to know that you don't have to be in Canada to apply. You don't have to be a Canadian citizen to apply. You don't have to be a Canadian permanent resident to apply. You can apply wherever you are and whoever you are. That doesn't mean that we're responsible for any of the immigration issues. You've got to figure that out for yourself. But that's not something that we worry about. We don't require it. There's a cost, and I think all things considered, not an exorbitant cost. The timeline, as Deborah says, is intended to be completion within 3 months of receipt of all material. So you should understand that if you haven't got everything together, we're not whirling away, getting ready to look at everything. We're going to wait until the package is done. So the policy, and the policy is on the website, it came into effect on January 1, 2015. The second bullet is worth understanding, at least in policy terms. The Federation of Law Societies, because it's the voluntary association of law societies, does a number of things to harmonize legal regulation across Canada. It'd be fairly stupid if the fact that professional regulation was an Ontario responsibility, if Ontario did it entirely different than BC and entirely different than Alberta. We want lawyers to be reasonably mobile within Canada, and we've spent a lot of time making sure that works. But we also want lawyers to be comparably assessed, comparably trained, comparably educated, and have comparable conduct requirements. And so one of the things that the Federation of Law Societies did back now, coming up to 10 years ago, was established what they call the National Requirement for Canadian Common Law Programs. Ontario could have done their own. Ontario could have said, you know, U of T, Osgoode, UBC, this is what we expect from you. And it could have been different from Manitoba, and it could have been different from Alberta. But we didn't do it that way, or at least we used to, but we stopped. What we created was a national requirement for Canadian common law programs, where all of the Canadian law societies have agreed on the standards for the law school degrees that they will accept. So the second bullet says that the NCA policy is intended to reflect and be guided by the policy for Canadian law schools. We're not trying to create a different system, we're trying to create an equivalent system, and I assure you we're not trying to create a harder system. We're wanting to make sure this isn't a barrier to entry, but a second way of assessing the same things. So the intent is that the Canadian requirements, or the requirements for Canadian law schools and the requirements for NCA applicants coming in, recognizing their different streams, are directly aligned. That's the intent of it. So what does the assessment look like? As I said before, depending on your qualifications, you might be required to complete examinations or law school courses, or you might be refused recognition. I'll tell you the numbers of this down a few slides later, but there are times that the NCA assessment says, you know, we don't think that we should give you any accreditation. We think that if you want to become a lawyer in Canada, you should either go now to a Canadian law school or get further accreditation, because we don't think either by further examinations or by further attendance we can get you where we should. So criteria for assessment: where you went to law school, where you did your legal training matters. The NCA deals with Canadian common law, so not surprisingly, if you are trained legally in a country that is a common law tradition country, it's a whole lot easier to show that your education is proper training for common law in Canada. On the other hand, if you're trained in a pure civil law regime, I think you would not be surprised that we will worry whether or not that training is transferable. Some jurisdictions are mixed. In fact, you can look at Quebec as a mixed jurisdiction, partly common law, partly civil. That's true in other countries as well. And there are some jurisdictions where their law is yet different again, sometimes a combination of religious law and common law, sometimes a combination of religious law and civil law. We have to sort through how to think about the country where you're trained. We don't spend much time, if any, thinking about the university in which you were trained, because we rely on the country to tell us which training is good training from their perspective. We don't, in effect, accredit law schools or universities. We, in effect, accredit countries. We don't say it that way, but that's the thought. The mode of study: the Federation national requirement requires in-class training. As a result, there are requirements in the criteria for assessment about in-class as opposed to distance training. I've had some NCA candidates spend a lot of time talking very loudly at me about their disagreement with that policy, and I understand why there can be debates about it. I'm not here to defend it, I'm just here to tell you that it exists. I think it'll be interesting as technology moves forward and technological ability to create an experience with others increases, whether or not that will change. But we do think it's important that people work together, work in groups, have ordinary human experiences with their teachers and with each other. And that's part of our conclusion so far about how education should properly be undertaken. Whether or not your law school, whether or not you got your legal education in a law school that was recognized in your jurisdiction. In the United States, for example, there are lots of law schools that exist but aren't recognized by the American Bar Association, which is the accreditor. We're not going to accredit, but we're going to look to the ABA at whether or not they have. The same will happen in other countries. We will look at what courses you actually took, and I'll tell you a bit more about that, but I've told you some already. And as well, if you've been licensed and if you've been in practice as a lawyer, that may fill some gaps or may reduce the number of examinations if you can show that you've had relevant professional experience. We have a number of people who particularly come to Ontario and say, hey, I was a paralegal for 5 years. Ontario licenses paralegals. Why the hell doesn't that count? And so far our policy says that it doesn't. Again, I think there are some interesting arguments about that. In England, chartered legal executives, we don't yet include practice with that qualification in England, and yet the English Legal Services Board considers that, in effect, a legal credential. Maybe we should do more. But so far what we do is look at practice as a licensed lawyer as being something that can supplement, something that can fill in gaps around education. So I told you I'd tell you about the subjects, and we require examinations at a minimum to be written in Canadian administrative law, Canadian constitutional law, Canadian criminal law, foundations of Canadian law, and don't ask me what that means because I can't really tell you. And finally, Canadian professional responsibility. This is because we think it's important to be able to show that wherever you were educated around the world, when you're starting working for clients in Ontario or other provinces, we're able to say to the public that we serve, all of the lawyers licensed in our jurisdiction have training in these core topics. It's not because we think that you're not well trained, it's that we think clients deserve at least these basic courses. One controversy I think is kind of interesting around Canadian professional responsibility. We've seen some Ontario paralegals who actually have to pass licensing exams in professional responsibility. I'm going to be interested to see if they start arguing, they haven't yet, hey, I'm already a licensed paralegal in Ontario, I've already got the licensing exams for professional responsibility, why are you making me do this again? These are things that are worth thinking about. This isn't a perfect system. We also require contracts, torts, and property. All of that comes out of the Federation national requirement for Canadian common law programs. You are not treated differently in this respect than Canadian educated licensing applicants because they have to do the same things as well. Until January 1, you also had to do business organizations, which is what it was called when I was in law school. It's essentially business law, corporate law. That got dropped for the Canadian law schools as a mandatory and therefore got dropped from the NCA as a mandatory. So what I'm going to give you now are sort of some typical pictures, typical scenarios that give you a bit of a sense of how the analysis would work. So let's look at someone who's trained in common law. Let's imagine somebody went to university in England, somebody went to university in India, lots of other examples. First of all, we've got a minimum pre-law education that's required. In Canada, you have to have at least 2 years of undergraduate in addition to a law school degree, so there's a comparable requirement. We look at the nature of the degree. Canadian law school degrees are 3 years, but that's not true in other countries. Some countries you go directly into a law school degree. In fact, you do that in Quebec, but it's longer. Sometimes you go directly in and it's shorter, and sometimes there are other variations of it. And so we have to look at the law school that you went to and try to understand its comparability to the Canadian system, which is 2-year minimum plus 3 years. 2-year minimum is illusory. The competition for law school spots in Ontario and in Canada is such there are about 3.3 applicants for every position. There are not very many people who don't have an undergraduate degree, and there are lots of people who have masters and PhDs. That's because the numbers applying are so great that somebody with 2 years of undergrad rarely gets in. We then look at the nature of the degree. Is it a first-class degree? Is it not a first-class degree? You can see that in this context, we're accepting that it's a common law country, and we're accepting that it's an accredited law school or a law school that's recognized for licensing purposes by the SRA or the Bar Council. But now we're dropping down to have our own understanding of the law school. We then look at the courses taken, and we look at whether or not these courses, the mandatory and core subjects, have been tested or learned. And we look at the academic performance on the courses. It's not enough just to pass. To do almost to fail is not good enough. And so we have a calculation which says how far are you off the bottom, and frankly we don't want the very bottom. We then step back and say, did you attend law school, bar school? Were you licensed? Did you have professional experience? And to give you an example, if you didn't take contracts or torts, but you worked in practice and you were licensed, and you worked in a practice where you dealt with contract law as part of your practice, it would be perfectly legitimate for Deborah, the NCA, or for you to say, why are you making me take this contracts exam? I've actually been licensed in England, to pick a good example, and I actually worked in a law firm doing commercial work. You don't need to test this. And so those are legitimate things to talk about. So if you look at this sort of fact pattern, Deborah would say that typically 5 to 7 exams are going to be asked for. And if you look at the Canadian exams, that's how you easily get to the 5. And she says that if you're licensed, not just educated, say in India, but became a called to the bar in India, it would be more likely 5, the mandatory Canadian 5. So what we're really saying here for this fact pattern is that someone trained in this context, we will treat them as well trained, but we want to make sure that their clients are protected by them having knowledge demonstrated with respect to Canadian work. Let's take another common law jurisdiction, the United States and Australia. The American Bar Association or the state are the determiners of whether or not the law school is accredited. There are no Canadian law schools that actually graduate people that aren't accredited, but there are lots of them in the United States. There are a surprising number of law schools. Again, look at the core competency list, look at academic performances, look at licensing, look at experience. And Deborah says that the norm, if licensed, is 5, so it looks like India, it looks like England. 5 to 6, she says, is more typical. I have no clue why there's rationale for India and England having likely one more than US and Australia. I'm sure there's a rational reason Don't ask me any questions, I won't give it to you. So the third example is distance education, and we require 2 years in-class training, including the core subjects. As always, the institution has to be approved. We again look at the classification of the degree, we look at licensing, we look at practice, and we look at professional experience. But the key thought here is that if you don't have the 2 years in class, then that's a problem. And the most recent example I've seen in appeals, if my memory is right, is the University of London, which does distance education. And we had one recently where we had an applicant from Hong Kong who went to a training program in Hong Kong that was affiliated with the law school in London, and their degree was recognized by England but not by Hong Kong, despite it being in Hong Kong, and it was distance as well, and we had to sort through on appeal how we would deal with that. And how we dealt with it was the policy as it now stands requires the 2 years in class, and we feel obliged to follow the policy as written unless there's a really compelling reason not to in a particular circumstance. And if the policy should change, then we should change the policy. Number 4 example, this is going longer than I'd guessed it would, is hybrid, common law and civil law. So the analysis is not different, really. All of the same things that in the previous examples have been worked through are worked through here, except that because it's a mixed tradition, civil and common law, we don't have the same level of confidence, and so we deal with that by upping it from 5 to 7 or 5 to 6 up to 8 or 9, just further assurance that we can show that common law skill is shown. And subject to the 5th one is Canadian civil law. Is there anybody in the audience who is coming from Quebec for this purpose? So I was going to skip ahead, but you get a private lecture. We look at whether or not you've got a civil law degree. I guess it could be Université d'Ottawa or one of the Quebec universities, Laval, Montreal. We look at whether or not you've got your licensing, whether or not you've completed professional responsibility. We know that the Code of Professional Responsibility in Quebec for lawyers is not fundamentally different than it is in Ontario. Typical assessment is 7 exams because common law tradition is, of course, different. But we will look at your practice and licensing in common law so that if you've done common law work, that may reduce the number of examinations. If you're coming from a country and a law school with no common law content, we look at something called JuraGlobe, which tells us how to think about these different countries. We really are incompetent to go away and do assessments of every country around the world, so we have to look to a reasonable source to make our judgments. And the bottom line is we won't recognize those degrees unless there is substantive common law education or professional experience. And so an LLM is one way to achieve that, and licensing in another common law jurisdiction would be a way to deal with that. Things we think about, if you got a law school degree when I did, it won't help. But that's a long time ago. I don't know at what point it's actually stale, but it does become stale, and that makes perfect sense. If you haven't used it, then at a certain point it's not of value. And as well looking at compensatory qualifications, and those are listed in the policy, the most obvious being professional practice. Top countries, England last year 547, the United States 238, India 229, Australia 154, Nigeria 91, Pakistan 48, China 35, South Africa 32, Hong Kong, Philippines. The pattern generally is that England, the United States, and Australia are for the most part where Canadians go to get foreign legal education. And certainly a number of people from those jurisdictions are non-Canadians, but Canadians are a big part of those. If you look at people who are coming to the country not Canadian-born, more likely to be India, Nigeria, and Pakistan. The NCA exams 4 times a year. There are 4 standard locations. We've just started up a new one in New Delhi. And I think something that is useful here is the last bullet point. If law school is required by the NCA to, in effect, top up your qualifications, it's for you to figure out how to get there. We can't get you admitted, although the law schools, I'm sure, are delighted to have you. But the point that I think is more hopeful is that about 85% of applicants do exams only. And I take that as a badge of transparency and fairness, that we are able to say that the substantial majority of people show us that you can do it, but we won't make you go through the hoop of going back to school. I think going back to school has some value for those who don't come from a country, but this is the way it is. Law school initiatives to help foreign trained. You will know of these, and Osgoode, of course, will be the best. U of T, UBC, and Alberta do this as well. And I've told you all about this. The only thing I haven't told you about is that some will have a reduced amount of articling required based on what your experience is in your home jurisdiction or original jurisdiction. That's not part of the NCA's job. That's part of the Law Society's job to sort that out. All the NCA does at the end of the day is give you a certificate or not. 17-18 last year, 911 certificates issued, 5,500 examinations. This is a big amount of work which is put into this. To go back to 2002, 15 years ago, it was like 200. And about 100 of those were for Ontario. This has exploded. And I think that must mean that people think it's attractive to be in Canada, and it's attractive to be in law in Canada. And I'm certain the first is true. The second is arguable, depending who you talk to, but there are worse things to do. This is where we are. It's now just about 2 o'clock, and I'm told that I'm to be off the stage at 1:15. I thought I would wonder how I'd use up all the time, but I've used up most of it, but I'm happy to have your questions. Yes? Sorry, I can't hear you very well. Is there a microphone that can be used, or?
Hello? Yeah.
Thank you.
Because I come from a civil law jurisdiction from Brazil, and they told me I'm not going to get any recognition. So I'd have to attend or to Juris Doctor and start from zero or come to an LLM. So if I came, for example, to the LLM of York University, and it took like all those 9 core subjects, after I got like another assessment, would I have to take more exams, or would that be enough?
I wish I knew how to answer that accurately.
I can answer that question.
Excellent. I've got a lifeline.
Okay, great. And I'm just going to put in a little plug for anybody who doesn't have sort of a good general understanding of the NCA requirements. We have a video on our website, the Osgoode PD website, on how the NCA process works and some of the ways you might use an educational program to work your way through it. We also run info sessions on a regular basis, so everyone's welcome to sign up for those. They don't have any cost and they're remote. So for civil law trained graduates, essentially we always recommend that you do send your credentials in to the NCA to make sure that they can determine that your law degree is accredited. because there are some jurisdictions, in particular China, that are a little bit tricky in terms of some things are called law degrees and they're not recognized as accredited law degrees. So it's a good idea to send in your materials, and you'll get the standard letter that says, hey, this is great, you have an accredited law degree, but we can't issue you an assessment because you don't have common law education. Generally then, if you go into an educational program, at a certain point you will be able to send a transcript to the NCA and get your formal assessment. And at that point, they're going to use the policy that exists at that time to issue your assessment. So under the current policy, there are the 5 mandatory subjects and 3 core, so the total is 8. So if you were actually sending in a transcript today, generally they will accept the transcript after you've completed 4 out of the 8 subjects. And then at that point, you'd get your assessment and they would tell you what you still have to do. Generally, at that point, you'd be given the option of either completing the remaining subjects with exams or with courses. So, but as always, we can't give any guarantees because the policies may change. And although the assessments are very consistent, there is always discretion for individual applicants.
Any other questions that I can't answer?
Hello. Hello, sir. You mentioned ABA is the accreditor when we pick American law schools. What accreditor should we check if you want to pick one of the Australian law schools? I know SRA is the body for UK law schools. I was like, when I searched myself, I saw like 3 different bodies, and I got really confused as far as picking Australian law schools.
So Australia, like Canada, is done by different states, what we would call provinces, they call states. So the biggest state in Australia is New South Wales, and so there'll be an accreditor in New South Wales. I think it's the Law Society, but I may be wrong. The other states are Victoria, Queensland, the Northern Territory. So as long as you find the right one of those, the major law schools you'll find are either going to be in Queensland or New South Wales or Victoria.
I want to ask you a question about abridgment articling. You told us nothing about this, about articling and how we can go through this, or without this.
That's a question for the Law Society. That question about abridgment of articling, we can certainly ask our Law Society representatives, and they're coming next.
Yeah, next session. I know about that, but I'm not allowed to tell you.
You have your NCA hat on today. Question at the back? No? I'm going to come around with the microphone. I'm just going to give this gentleman a chance first. Missed my calling as a talk show host.
Thank you. I come from Mexico, that is a civil country. It doesn't take any common law, so basically you should take an LLM here in Canada and then go to the NCA. That's how I understand it. Is that okay?
What was just said, if I understood it accurately, is it's worth applying to make sure your degree is recognized. If it isn't, then you're going to have to think about getting a recognized degree. If it is, Osgoode would say that an LLM is a practical way then to get the courses that you need. And while there may be 7 or 8 courses that you need, if you get 4 of them, you can apply then and make sure that you're on track, and then decide whether or not to do the remainder by exam or by course. Do I pass?
Yes, thanks.
Excellent answer, and I'll put in a plug for our alumni panel later today. We're going to have a number of civil educated alumni who are now licensed, so they can share their experiences with you.
Sorry, I only have a civil law degree in China, and now I am in LLM program. But my program does not cover every core course of you have mentioned in the slide. So if I only take a part of the core courses in my first LLM degree in Canada, in Osgoode, and then I go to assessment, then the rest one will be in to pass the rest assessment. So will be the exams or courses. Can I choose, or they will decide it, or which course is must be passed by courses, not just exams. So, thank you.
I'm going to pass that to an authority.
Thanks, Malcolm. I spend a lot of time talking to Deborah, so I probably know these things almost as well as she does. So for people who are from civil law jurisdictions, and this probably is equally applicable to anybody who has not had their degree recognized by the NCA and they're told to go back and do some common law education. It really depends. So if you come and do an LLM, we have like 15 different LLMs at Osgoode. So if you were to come and do, say, the professional LLM in business law, and then apply for your assessment, it would be up to the NCA to figure out whether there was enough common law content in that degree to issue you an assessment. If they felt that there was enough common law content, they would issue you an assessment that allows you to write exams. If not, they would want you to do more education. So the thing to look for, always it's a good idea to ask them for guidance, even though it's not an assessment, so it's not binding, but it will give you sort of a sense for whether you're on the right track. Degrees that are a little bit problematic in terms of getting an assessment, if you're looking for common law education, would be things that have a really heavily international focus. So for example, I've seen candidates from civil law jurisdictions who have a degree in something like international human rights, and the NCA says, no, that's not a common law degree, that's an international law degree, so we're not going to give you an assessment. So it depends on the content of the program that you take. Most of the ones that we run at schools like Osgoode would have enough common law content that they would issue you an assessment at the end and let you take exams. How are we doing for time? We've got about 5 minutes. Did you have another question here in the front, sir?
Hello. So I saw a Law Council of Australia. Is that something you want me to check before I don't want to end up in a non-accredited Australian law school.
Well, the easy way to sort it out, it would be simply to give a call up to the NCA and ask who the accreditor is for the law school, check out to see if it is accredited. It should not be difficult to inquire.
Right. And you're saying it's different for every state, like in or province, like in Canada?
Yes, that's right.
Okay.
So in Australia, legal regulation is done state by state.
Right. Okay, will do. Thank you.
But it's very clear, the NCA knows clearly which universities in Australia are accredited. They're such a big source of NCA applicants, they're well known.
Yes.
Thank you. I have a civil law degree and I'm doing my LLM right now. I'm waiting for my assessment. So I understand that the rule is to have 8 exams completed in order to get a certificate. But I was just wondering if it's possible they give us more than 8 or less than 8. I'm a bit anxious. I'm waiting for my assessment. Maybe that's why I'm asking.
Yeah. So it's always open to the director to assign more or fewer. And it could be based, for example, if your academic qualification didn't look strong, and I'm sure yours would be looking strong, but if for a candidate for whom there are some doubts, one of the ways to address doubts is to assign more examinations. And on the other hand, if there is professional experience, which allows the assessor to be able to say, we really don't need to prove contracts because we've got this experience in the common law context, then that exam may not be required. So there's a sort of a standard predictable answer, but there can be reasons to go up or down. But there've got to be reasons. It's not a random thing.
I think we have time for, let's just do one more and then we'll wrap up for Malcolm.
Thank you. I also come from a civil law jurisdiction, and my question is it guaranteed that after we finish all the courses, we're going to get the certificate to write the bar exam? Or is there any possibility of the NCA coming back and saying, oh, you have to go back to law school and get like a JD or something like that?
Well, the NCA doesn't give guarantees. What it does do is have policies, and it follows its policies carefully. Policies can change, and the policy that's the relevant policy is the one when you make your application. So I don't want you to think that it's sort of scary, random, and always changing, because it's not. But I can't promise you that it's guaranteed either, because things can change, and it can be a question of the interpretation of the policy. I think mostly it's pretty straightforward.
Yeah, I mean, the assessment methodology is pretty predictable. So where you see that where you have risk is where you don't have an assessment yet, and the policy may change. So just by luck, the last 2 policy changes have been favorable to civil law trained candidates, but the 2015 policy change was very unfavorable to distance education graduates. And so there were lots of people in distance education programs thinking that they would have 8 exams and 1 year of in-person education, and the policy changed to require 2 years of in-person education. And so people who didn't have the assessment yet would be assessed under the new policy. Generally, the policy changes are not retroactive. Once you have your assessment, it has a 5-year time limit on it. And so I think from a regulatory and legal perspective, that is a binding assessment as between you and the NCA. So as long as you follow those requirements, you should be fine. They would have to make a fairly significant retroactive change to invalidate people's assessments.
And we haven't done that. You know, the one I can think of where we did make a change which was unfavorable was dealing with one university in Australia, which had special status. We took away the special status, but we did it over time, so the people who had already committed to the university had the benefit of the past policy.
That's right.
We don't want to hurt people on the way through.
Yeah, but really, I mean, I have to give a shout out to the NCA because, yes, they're a regulator, and so they're not there necessarily to do things in a way that's favorable to individual candidates, but they do apply the policies really fairly. They're really responsive to questions, and they do try to do things that are helpful to candidates when they can. So just as an example, we have all kinds of arrangements with them to send letters of completion on interim bases so that people can move on to licensing. And the NCA isn't required to agree to those things, but they do because they know that the stakes are really high for people.
There are some places and some professions where they try to limit new entrants because they don't want competition. That isn't what we're about. You know, we're consciously trying to do the thing which we ought to do, which is to make sure the people that are served by lawyers are well treated by making sure the lawyers that serve them are competent. That's our mission.
Great. So on that note, Malcolm, thank you so much.
Thank you.
It was great. So we're going to start our next panel in here at 2:15. Everybody from the other room is going to rejoin us. So if you need to shift around or stand up and stretch for just a moment, please do that. But let's not go too far afield so that we can continue on time. Thanks. I have a remote for the PowerPoint, or I'm happy to drive it for you.
So I can do that. Sure, that's fine. I'm kind of a table person, though I see there's a point there. I was going to more to say, maybe
Yes, there is.
Okay, then yeah, well, you know what, we'll sit at the table. And we can make ourselves at home. Is it F5? How do you get it to go full screen?
I'm going to do that now for you.
No, I'm sorry.
Okay, everyone, let's get started on our next panel. I hope that those of you who were across the hall enjoyed the career counseling advice as much as we enjoyed Malcolm Mercer's presentation on the NCA. Lots of great information. So without further ado, we're going to move on to talk about the licensing process, and we are very, very pleased to have 3 speakers from the Law Society of Ontario here today. This is a really exciting time for licensing because there's a consultation report out. I don't know if any of you have taken a look at it. The Law Society of Ontario is really thinking hard about what the licensing process should look like longer term. I don't know to what extent our panel wants to take questions on that later today, but that report is available on the Law Society's website. So I'm pleased to welcome Ken Osborne, who's the Manager of Licensing and Accreditation, Gina Harros, who's the Team Manager for Licensing, and Claire Hepburn, who's the Team Manager for Articling, to present to us today. And they are going to reserve some time at the end to take some questions. And I know they have a lot to talk about. So without further ado, let's get started. Thank you.
Thank you very much, Megan. Well, thank you for having us here today and for giving us the opportunity to talk a little bit about the licensing process. And it also gives us an opportunity too as well to welcome you as prospective licensee candidates to the Law Society and to the legal profession in Ontario. It is without a doubt a vibrant profession. The Law Society of Ontario is a remarkable organization in my view. That has a profound mandate to protect the public interest and ensure that the competence, the capacity of both lawyers and paralegals in this province is at a high standard. And we take our role very seriously. In fact, the Law Society is an organization that unique in this country, regulates both lawyers and paralegals in respect of the complete provision of legal services in a province. And we feel that we provide a number of tools, services, resources, both to lawyers, paralegals, as well as to the public, to ensure that the quality of legal services in this province remains high. But at this point, it really is an entry point for you, and I want to take this opportunity on behalf of the Treasurer, on behalf of the staff of the Law Society, to take an early opportunity to welcome you and to hope that your movement through the licensing process is expeditious and rewarding. So I have with me here today Claire Hepburn and Gina Harros. I do want to mention a little bit that the portfolios that both Claire and Gina are responsible for. It was mentioned that I am the manager for licensing and accreditation. I am responsible generally for the overall planning and execution of licensing and accreditation operations for the Law Society. Claire is responsible as the team manager for the articling process, for the planning execution of our day-to-day operations in respect of the experiential programs that the Law Society is operating. That would include articling, that would include the LPP and other experiential programs that we offer in respect of the licensing process. Gina is responsible for planning and execution of the day-to-day operations of the Law Society, the Law Society's licensing process, which is a rather cumbersome and large portfolio considering the volume of candidates that we have in any given year. Her mandate includes processes and activities that support both the paralegal and the lawyer licensing process, so it's a rather large portfolio. So I think I'd like to start just by giving you a sense of what the pathway looks like, the pipeline to licensing, if I could put it that way. Unlike any pipeline, there's a start and there's an end. And for all of us prospective lawyers, it really starts with graduation from an accredited law school. In respect of many of you here in the audience today, it starts with your accreditation from the National Committee on Accreditation, a certificate of qualification that says you are able to enter the licensing process and embark upon the procedure and process to become a lawyer in this province. And really, when you start that process, your first interaction will be with Gina's team and her coordinators and administrators that will help move you through this pipeline towards licensure at the end. There are some elements that I want to draw to your attention because I think they are important. They're often sometimes missed in terms of what the Law Society expects of an applicant. Of course, graduation from an accredited law school or a certificate of qualification is the first piece of information that we do require. But there's some other elements as well, too, that are important to draw out. And one of them is this requirement to be of good character. And more will be spoken about that, but there is an obligation, as you would expect, that because you are entering into a regulated profession, that you must conduct yourselves in a manner that is regulated, and that you must have a measure of good character. And that is looked at, your background, your experiences. You will be required to make some declarations in respect of who you are and what you represent, and that will be looked at as part of the application process. And it's a self-reporting activity, and it's a continuing activity, and your obligation to be of good character not only starts at the time of the licensing process, but continues all the way through your career as a regulated professional, as a lawyer and licensee with the Law Society of Ontario. And certainly with the application in the licensing process, any changes to good character while you're in the licensing process need to be brought forward to the Law Society so that we can have a look to see and determine whether that impacts your ability to continue on in that process. The other elements that I think I need to draw out, and probably some of the elements you're already aware of, if not have already undertaken, and that is the licensing examinations that lawyer candidates must undertake. And there are in fact two. This session will talk a little bit about the examinations in a little bit more of a greater focus. But it is a requirement as part of our licensing process that lawyer candidates complete both the barrister and solicitor examinations. These are high-stakes exams. I don't want to back away from that. These are instruments, tools that are implemented to gauge and to determine entry-level competence of new lawyer candidates. So they are measures that have to be undertaken and successfully completed. The other elements of the licensing process that I would draw out as well is the experiential path. And by that I mean, it's one thing to have knowledge. It's one thing to be academically inclined to the practice of law. It's one thing to be able to research and write. Of course, those are all important things that lawyers must be able to do. But it's the practice of law, the ability to be able to provide advice that is focused, operationally focused, and catered to the client's needs is something that is not necessarily something that's trained through the course of academic studies. I used to be, I'm just going to break for a moment here and mention my former capacity as a military lawyer. We used to actually take qualified lawyers and put them on occupational training. And even though these individuals were lawyers and could provide advice, they couldn't necessarily be military lawyers at times because they weren't able to actually provide in a focused, operational manner legal advice that was relevant to the client and relevant to the needs of the situation, and those individuals sometimes did not make it through. So this notion of being able to practice comes into play into our licensing process. And there are there's actually more, but there are two principal components of the experiential process that I think you will need to turn your attention to, and that is the experience that is derived either through articling, which is the opportunity to be positioned or placed along with a supervising lawyer and given exposure to various practice areas in the context of an actual practice, and actually having carriage of files, actually having carriage of issues that require resolution under the supervision of a lawyer. And that is traditionally done, or has been traditionally done, through the process of articling. Over the last few years, though, as a result of the pressures that the limited number of articling positions has resulted on our profession and our ability to sustain the licensing process, the Law Society has developed additional protocols to ensure that candidates have an opportunity to meet those experiential requirements. And the law practice program, again, you'll hear more about that a little later on in the presentation, which is delivered both by Ryerson in respect of the English program and by the University of Ottawa in respect of the French program, provides another means of meeting that experiential requirement, a very interesting and, in my mind, effective way, in a sense that it provides a synthetic practice environment leading up, and then it is finalized or capped off with an actual work placement. So again, like articling, it exposes you to the foundational elements of actually practicing law, and at the same time providing you with a degree of work exposure under the supervision of counsel, with carriage of files and activities that you would actually perform as a student at law. There's an element on this chart that I don't really need to mention in your particular case, and that is the Lakehead University Law School program, which is an integrated experiential process. Since you're not in that process, it's not something that would apply to you, but really to sum up in terms of the licensing process that you will experience, the elements really are graduation from a law school, accredited law school, or having a certificate of qualification from the NCA, meeting the requirements of good character, to be a regulated professional in this province, writing and completing successfully both the barrister and solicitor examinations, and either by way of articling or the LPP, the law practice program, meeting the requirements of the experiential practice components of the licensing process. And with that, of course, there is the final ceremony, the call to the bar, which is not only ceremonial, but also there's elements of it as well, too, that support your ability to appear before the courts in this province in terms of signing the rolls and whatnot, which is the final process, the piece that actually kind of grants to you the licensure to practice law in this province. So perhaps without further ado, I will turn it over to Gina.
Thanks, Ken. As Ken mentioned, we're happy to discuss the mandatory components of the licensing process today. I will be dealing primarily with how to get into the process, how to apply and proceed through the steps that are required in order to be licensed. And Claire will speak directly to the articling portion as well as the law practice program. And we'll also, at the tail end, you'll know you're in the home stretch if we start talking about supports and things that we offer you while you're in the licensing process. So we'll get started now and take a look at what you should expect in the licensing process on your path towards becoming licensed in Ontario. In terms of getting started and applying, it's an online application process, and that is part one of what we require you to do. So once the application launches each October, we expect applicants to go online, enter their information and their education information, as well as their exam choices and how they intend to, which sittings they intend to select. And so once you finish the online application, you will then be expected to print that off and send it into the Law Society with all of your supporting documentation. So it's done in two parts. Again, the first part is online, and the second part is done by mailing us the information. Once you apply, you'll also receive a personal and confidential email account, and that's the account that you'll be checking later on in the process to receive your exam results, notifications, invoicing, all of those things, similar to what you've probably received thus far from your schools. The number one question that we get from candidates is when they should apply, what's the timing, when can I sit the exam, when am I eligible? And I would suggest when you're thinking about when you're going to select your sitting and what you're going to do and what sequence and all of that, it can be a little bit daunting. But I would suggest that you would consider when your credentialing is going to be complete. So that's going to be the most important thing to consider. So when you're finished your credentials, you've completed what you are required to do, then you'll start to get a sense of which sitting you'll likely be eligible for. We do have a 30 business day deadline before each examination sitting, and you'll need to kind of stick to that depending on which sitting you select. You'll also need to keep in mind that even before you prepare to register for that sitting, you need to finish your application process. So the first part is application process. The next step is registering, making payment, and all of the administrative requirements that you'll need to submit to the Law Society in order to qualify for those sittings. Then you'll also need to consider what your personal circumstances are. So, can you commit the time to prepare for this examination sitting that you've selected? If you're working or if you have family obligations, all of that needs to be taken into consideration. But if you have specific questions about the timing, we're happy to address those with you offline if you call our office when you're prepared to select a sitting, and we can give you a little bit of a better sense of what's available to you depending on your circumstances. So the licensing year for all candidates begins May 1st of each year and concludes on April 30th the following year. So anyone writing in that licensing year will have 3 opportunities to write. We have the larger June sitting for both barrister and solicitor. Then we have a November examination, and then the final one in the licensing year will be in March. So if, for example, you were interested in writing the examination in June of 2019, which is about a year from now, you would be applying to the process this fall when the application launches. That's a general rule. You don't have to select the June selection. You can also opt to write in November or March, whatever suits your personal circumstances. And again, we're happy to kind of guide you through the process if you call the office or email the office, and we'll give you a sense of what's available to you, how to structure your time and prepare for not only the application process, but also for the registration and studying for the sitting that you selected. And the topic that we get the most questions are, obviously, is specifically around the examinations. So you must complete the barrister and the solicitor examinations. It's 2 distinct examinations held about 2 weeks apart in each sitting. So for example, this month in June, there's an examination next week for barrister, and 2 weeks after that, there's a solicitor examination. You're able to select whichever sitting you like, so you can select to write barrister in June and solicitor in November. If you wanted to split them up, there's a little bit of flexibility there, so you can certainly do that. So you're permitted up to 3 attempts at each of the examinations within your 3-year term. And exams are typically held, like I said, 3 times a year, and they are open book, multiple choice, and 7 hours in length. So there's a 3.5-hour portion in the morning and a 3.5-hour portion in the afternoon for each exam. In order to prepare for the materials, you'll need to rely on the materials provided to you by the Law Society. The examinations are based on validated entry-level competencies, which have been defined by the legal profession through a rigorous development and validation process. There are several hundred competencies listed in great detail on our website, so I encourage you, when the time comes, for you to review those. But essentially, the competencies that are tested during the examinations include those that have the most direct impact on public protection, those that influence effective and ethical practice, and lastly, those that can be measured reliably and validated by the assessment question format used in the examinations, on the examinations. So study materials are typically released in April of each year, so just before the licensing year commences. The distribution period starts in April, and those materials will be relevant to any examination written in June, November, and March of that year. So you'll have approximately 6 weeks to prepare if you pick up your materials in April and intend on writing a June exam. Candidates often ask us how to prepare for these examinations. They are, the materials are quite lengthy and it seems a little bit intimidating. Obviously, Ken mentioned they're high stakes examinations and people want to do well. They ask us, how am I going to prepare for this? What's the best way to pass? What do I need to do? And, there's no one best way to prepare for these exams. There are almost as many studying styles as there are candidates who write our exams, but most importantly, performing well on these exams relies on you knowing the materials thoroughly. I don't think that's a great secret. I think that's pretty standard in any examination. But while an open book format means you can bring the materials in, it doesn't mean, although I have seen it, that you rip the materials open at the exam site. So, they require you to analyze the information within the materials, apply it to new situations, and this requires you to review them very closely and at length. As I mentioned, there's no one best way. However, there are some techniques that typically seem to help people prepare for the exams. And first, most candidates find it useful to implement a study strategy very early on. So as soon as they get their materials, this can include making a schedule for when they will study, how long they will study for, and it's always a good idea to start right at the beginning. So the earlier, the better, as opposed to cramming it all at the 11th hour. You won't retain the information. It'll be difficult for you to recall it while you're in the exam. And again, high stakes exam, you really don't want to leave anything to chance. Given that it is an open book examination, you also want to take a moment to think about what types of materials you want to bring in to the examination. Obviously, I've mentioned the exam materials that we provide you with are what you will need to prepare. But you can bring in a dictionary, you can bring in any other law books that you like. You just have to keep in mind that once the exam concludes, you have to leave all of that in the exam site. Okay. The other thing is to make the materials user-friendly for yourself. So, use tabs, color coding, prepare an index, whatever helps you be successful, that's the strategy that you should work with while you're studying and what you're going to use on the day of the exam. So some candidates may find tabbing, indexing, or highlighting the materials helpful at the outset of their preparation in order to be ready, while others prefer to do that at the end so that they can round out their studying. Again, the best approach is the one that gives you the most confidence to walk into that exam site and feel prepared and ready to tackle the exam. Keep in mind again that the exam is in a multiple choice format, and we have some material in our exam guide online that you can also review to kind of get a sense of how the questions are structured. They're by no means meant as a kind of study guide. It's just giving you a sample of the types of questions that you can expect in the exam, how they're formatted, what they look like. You may also be aware of some preparatory courses for the exam that are out there, and it's certainly your choice if you wish to partake in that. But remember two things. First, none of the courses are endorsed by the Law Society, nor do we provide them with materials on which they can base these courses on. And second, the exams are based on the materials that you're provided by the Law Society. So something to keep in mind when you're preparing. There are some sections of the website that I encourage you a little bit later to review. There's a very helpful video online that'll show you sort of what to expect, what the exam venue looks like typically, some of the security protocols that are in place at our examinations, what you can bring in. Believe it or not, there's a prohibited items list. It's all very formalized and posted on the website for you to review. And this is because, obviously, we have to adhere to those protocols, but also to prepare you for what to expect. There's a clear Ziploc bag in which you put in your personal items. So all these little things we want to post out there so that you're prepared. You don't leave anything to chance on the morning of the examination, and you can basically arrive feeling prepared, calm, and ready to do battle, so to speak. So, and before you know it, you'll be writing your examination. So, after the questions on examinations and study materials, the next highest call that we get is, how did I do? Did I pass? Did I pass? Did I pass? That's a typical question that we get literally the day after the examination sometimes. So it takes a little bit longer than a day to get the results out. I think we are at about 6 to 8 weeks time frame for us to get the results out to you. And I know that sounds a little bit long, and we don't want to keep anyone in suspense. We know that, everyone is anxious to receive that great pass. However, we have multiple sites, accommodation sites, various venues, and in 2 official languages. So by the time we receive everything, mark it, score it, double check it, validate it, and then get your results out to you, it does take a little bit of time. So be patient. We won't keep it a secret. As soon as we know, you will know for sure. And we'll send those results out in writing through your account. But word does get out. So as soon as the send button is sent out, word in the community gets around. So everyone knows that their results are out. Hopefully one day we can do that via Twitter or something like that. So now I'm going to hand it over to Claire, who will speak to some of the examination supports that we offer and during and experiential training.
Right. So I'm going to, first talk a bit about experiential training, and then we'll go back to some of the supports. So as Ken mentioned, one of the components of the licensing process is to complete an experiential training path. So in about 2014, the Pathways pilot project introduced enhancements to articling and the law practice program. So now there are 2 main options that you can select to complete experiential training. I'm going to go into more detail about what that is. But in terms of, to link back to what Gina was saying, when you submit your application, you're going to be given a choice around which experiential training path to select. And there are a number of selections to be made. If you have an articling position secured, you would select that and indicate where you're articling. If you're actively seeking an articling placement, you would select that option. You can select the LPP. And there are options that say neither LPP nor articling, and that would generally apply to candidates who are going to seek an exemption. I'm going to talk a little bit about exemptions, and there are very particular criteria for who qualifies for that. One kind of housekeeping thing I would note is if you do change your experiential training path, for example, you initially thought you would do the LPP and you find an articling position, just make sure that you update your information by either contacting our office or doing so on your online account. And that's going to be just a theme that we'll come back to. It's always important to maintain communication with the Law Society. In fact, they often say that's how most lawyers get into trouble, by not failing to communicate with the Law Society. So it's a really important thing when you do become a candidate in the licensing process. You will get a candidate account, and you'll have to go into that candidate account to retrieve your messages. So again, the three pathways are the law practice program, the articling program, and an exemption from the experiential training. A couple of other important things to note. To begin the experiential training program, you do need to be fully registered. So we do either need a transcript or the certificate of qualification, or a letter from the NCA confirming that you have completed that component. If you happen to be working during your qualification process, it's also very important that you make sure you're on side with the rules and regulations of the Law Society. In other words, you don't want to be engaging in any kind of unauthorized practice. So it's quite common for some candidates maybe to work in a law firm while writing your NCA exams. Just make sure you review bylaw 7.1. And that will they'll set out very clear guidelines, because those are different than when you do either a work placement in the LPP, the law practice program, or articling. So just keep those 2 points in mind. So the next slide should be law practice program. And that is, again, it's an 8-month program. The first portion of it, which generally runs from about September to December, is a training course. And then the second 4 months, which is usually about January to April, is a work placement portion. Ryerson University provides the English course, the English program, and Ottawa provides the French program. So there's slightly different formats with the training component. At Ryerson, a lot of the training is done online. There are virtual law offices and teams, and there are various points throughout the year where you will have to attend in Toronto. But a majority of it is delivered through an online format, whereas the Ottawa program is primarily in person in class. And if you're interested in this upcoming session, it would be September 2018. Okay, so the articling program, again, that's where most candidates will complete their experiential training. It's a traditional path. And just a few points there. Articling is currently 10 months in length, and you are required to article with an approved principal. So if you do find a job with a firm or a sole practitioner perhaps, and you're not sure whether the person is an approved principal, you can always contact the Law Society and we can confirm that. That's just an important point, because if you article with somebody who's not approved, you might not get credit for that. Again, it's the candidate's responsibility to find the articling placement. We do have resources that I'll be mentioning at the end, towards the end, to help you, to assist you in securing a placement, but ultimately it's up to the candidate to find the placement. There's quite a bit of flexibility as well within the articling program. So if you wanted to article with 2 or more articling principals, maybe you found somebody who can maybe provide part of your articling, and there's an office down the street who can do another part, then that would be called a joint placement. If you wanted to complete your articling not in a full-time capacity, that would be considered part-time articles. Those 2 options would just need a special application. Another option as well is to complete your articling out of province. So national placement would be considered anywhere outside of Ontario, and an international placement. There's some really interesting work that people can do all over the world. Just make sure that you submit the application before you begin articling to make sure you get all the credit. There are, of course, many filing requirements, and you'll all be lawyers soon, so you'll know all about completing filing requirements. I'm not going to go into too much detail about those requirements, but the most important thing to note is within 10 days of beginning an articling placement, you should have an articles of clerkship on file. If you don't have that document on file, then you might not get credit for your articling placement. At the end, there's another form called a certificate of service, which also needs to be filed within 10 days. We also have enhanced reporting requirements for both your principal and candidates, so those can also be filed online. So just make sure that we will be sending you lots of messages, and you'll be getting lots of communication from the Law Society, so do pay attention because there are important filing deadlines and registration requirements. So, as I mentioned before, there are resources to help you secure an articling placement. The first one being the articling registry. So that's essentially an online tool or a website that you can log into through the Law Society website and search active placements. So there are a number of placements listed. All those placements must be paid. That's a requirement for employers listing any job posting on that registry. So just keep that in mind. Another option that you can pursue is submitting what's called a biographical paragraph, and essentially that's just a brief description of your areas of interest, your skills and ability, a very precise statement. And from time to time, we'll get requests from employers seeking articling candidates, and they will ask to see that list. And so we can provide that. So if you've provided us your information, that can also be another way to connect with a potential employer. We also have a mentorship program that you can request to be paired up with another lawyer who practices in the areas of law that you're interested in. So that lawyer could be a resource to you to help you network, to find other resources, and otherwise support you in your search. And finally, the last bullet point here I'll mention is the recruitment procedures. So these are fairly lengthy with very clearly set out deadlines for when to apply and when the articling weeks. One point I will say, I'm not going to go into detail because I could spend another hour or two discussing those rules or procedures, but it's important to note that if you're looking for a job after those deadlines are passed, you're not required, we get that question quite a bit, you're not required to meet those deadlines. Those deadlines are applicable in terms of you're not permitted to interview before those interview weeks. Okay, so the next slide is about abridgements and exemptions. So there are two types of abridgements. Abridgements essentially is a reduction of the articling term. I'm just going to note that abridgements are only available for articling placements, not the LPP. You're required to complete all 8 months in the LPP. But if you have, for example, if you've worked at a law firm while awaiting accreditation through the NCA, for example, or if you've worked overseas and the important thing is it's after law school, so any experience you gain during law school wouldn't qualify for an exemption, but if it's after law school, you may be eligible to reduce the term of your articling placement. You just need to submit an application, describe how your experience relates to the experiential training competencies, so those things that would be similar to what you would be doing in articling. And because the experience is before call experience generally, it's not necessarily going to be granted at face value. So just keep those things in mind, and again, you're free to call the articling office and we can answer more questions about prior practice abridgements. Another type of abridgment is a compassionate abridgment. So candidates who are maybe experiencing unexpected illness or have other personal matters that require them to be away from their articling placement for up to 6 weeks can apply for a compassionate abridgment. And that's simply just writing a letter with the support of your principal. And again, our policies allow us to grant a reduction up to 6 weeks of your placement. And then exemptions. So exemptions are available for those of you who have been called to the bar in a common law jurisdiction and have practiced in that jurisdiction for at least 10 months. So if you've met those criteria, then you can submit an application for an exemption. If you don't meet that criteria, but you've had other experience, we would probably consider that as an abridgment, but you wouldn't be eligible for an exemption. If you are eligible and you've qualified and you've submitted the application, you would then need to attend a 3-day in-person at the Law Society course called the PCPO. And that would be a course that would introduce you to practicing in Ontario. And Ken and his team also deliver that course as well. So the next slide is on the rights of appearance. And as I mentioned before you start articling or before you start your work placement, you're not essentially conferred the rights of appearance. But once you have submitted your articles of clerkship, then you are permitted to appear in Ontario courts and administrative tribunals. But there are specific limitations to what you can do. So it's not a complete, you're not granted the same rights as a fully licensed lawyer. There is a document on our website that explains what those rights of appearance are for criminal law, civil law. Family law is a little bit different because they govern their own process, and administrative law. So often, every week we get questions about rights of appearance, what can I do? So if it's not clear, I first say read the rules and see if you can discern from the rules. And if not, you can call our office. Another really important thing to do is to contact the court, because courts have inherent jurisdiction to decide who can appear before them. So in some cases, if your principal's in attendance, you might be able to appear on a matter that you wouldn't otherwise. And again, if the rights of appearance state you'd be permitted, but the matter is very complex and you'd be perhaps putting a client at risk, then a court or a tribunal may not permit it. So it's just important to always be alive to the risk to the client. You want to ensure that the client's well served, whether you're appropriately prepared, and whether you have adequate supervision. And those are, again, questions that you and your principal would be best positioned to answer. The last point here is about supervision agreements. So if you happen to be working and your articling placement is finished, or your work placement with the LPP is finished, but you still want to perform legal services and you want to do so in accordance with the rights of appearance, then you just need to submit a document called a supervision agreement and have a supervising lawyer sign off on that. So it doesn't have to be the same as your principal, but it would have to be a supervising lawyer. So just another thing to keep in mind. You always want to make sure you're on side with when you do any kind of legal work. And if it's outside the scope of articling or work placement, then you have to be that much more cautious. So I think the next couple of slides are actually about the licensing exams. So I'm just going to go through. And then we're going to talk lastly about the supports in the examinations. So if you do need an accommodation for your licensing exam, the first document I would refer you to is the policies and procedures document that explains our policies and how to actually go about requesting it. There are very clear request deadlines on the website, and it's critical that you get all the documentation to us within those deadlines. Each accommodation it takes time and consideration in order to implement the appropriate accommodation. So our staff and our teams need that time in order to implement the accommodation. So just be very mindful of that. And of course, if you do have questions about that process and what you need to submit, once you've consulted the website, please contact our office and our examination accommodation team can guide you there. Another support that we offer, if you happen to be unsuccessful on your first attempt of the examination or any subsequent attempts, the Law Society provides up to 5 hours of tutoring in areas where you may need the support. So if you are unsuccessful, you'll see a document that explains where your weaker areas were. So it can be really helpful to speak with the tutoring coordinator as well to find out where you may be best may be best directed. And then there are some other licensing process resources that Gina's now going to be talking about. Sure.
So before I get to the financial assistance and other resources, I did want to mention we've been referencing the website constantly, and I don't know if everyone knows that we've recently changed our name, and we've gone from the Law Society of Upper Canada to the Law Society of Ontario pretty much overnight, it feels like. We're still in the process of transitioning, but all of our documents, all of the policy and forms, and all of the items that we're referencing in terms of the examination guide and protocols, that is all on the website, and that's www.lso.ca. So you can still search the Law Society of Upper Canada, and it'll still bring you to the information. However, we forgot to mention that at the top, and I know that we've been referencing quite a few forms and documents. So in terms of financial assistance available to you when you are in the licensing process, there's two programs that the Law Society administers in order to help our candidates through the process and paying their fees. The first program is what we call the RAP, and RAP is the Repayable Allowance program, and this is a sort of a short-term loan program where candidates can request up to $5,000 to cover off on tuition and a portion of their living expenses. So that is something that is available to you. There's a ton of information on the website and enrollment or an application form that I encourage you to look at if you're interested. The other program is the monthly payment plan, and the monthly payment plan will allow you to pay your tuition for the licensing process in either 5 or 10 installments, so it sort of breaks them up for you, which is also helpful in not having to kind of pony up all that money right up front. So that is available as well. The other thing we did want to mention as well is the Law Society's continuing efforts to enable equality, equity, and diversity in the workplace and the profession, and to help stop discrimination and harassment. We provide a discrimination and harassment council that's funded by the Law Society and free of charge to you. So they confidentially assist anyone who may have experienced discrimination or harassment by a lawyer or a paralegal. So again, those resources are all online, and the contact information as well. We've also, I believe, created an informative tip sheet for all our candidates who are in a work placement or articling position on what to do if discrimination or harassment occurs. And again, all of that will be made available to anyone in the process once they enter. So the last point is that I wanted to mention is the Member Assistance Program. And this is a confidential health and wellness service provided by Homewood Health. And it's funded by the Law Society as well, free for lawyers, paralegals, law students. And you can get information on that plan, which kind of offers counseling services, information, tools, resources on a number of topics, including psychological challenges, marital relationship challenges, stress, depression, anxiety that someone may be going through, and you can access that under myassistplan.com. Again, all of this information is accessible through our website should you need it. Now I'm going to hand it back to Ken.
Thanks, Janet. Okay, so we're now at the end of that long trail, that long pipeline of the licensing process, and we're at the call to the bar. And the call of the bar is both something that's ceremonial but also procedural. And you enter this process upon successful and satisfactorily completing the licensing requirements that are expected of you over the course of this time. So again, that would be applying, of course, by the deadlines, being a graduate of an accredited law school, having a certificate of qualification, being of good character, successfully passing both the barrister and solicitor examinations, and meeting the experiential requirements that the Law Society has set for lawyer candidates. So once that's all done, you enter the call to the bar process. We do provide quite a bit of information to prospective candidates on this process. You will receive a bulletin that sets out the nature of the proceedings, what to expect, the date and the time of when it will occur, the dress requirements that you are expected to be wearing for that ceremony, and generally the ceremonial protocol. And we do offer calls in a number of different areas across the province. Principally, though, it's Toronto, which is the main site, Ottawa, London, and I believe just London. Okay, so those three. So that's sort of the ceremonial aspect of the process. There is a procedural element to it, which is called signing of the rolls. This is really something that's done, again, only by candidates who have successfully completed the licensing requirements. You cannot sign the rolls until such time as you do successfully complete the requirements. The signing of the rolls process is something that the Law Society of Ontario does on behalf of the Court of Appeal and the Superior Court of Justice in respect of having candidates sign the rolls of these courts in order to be admitted to these courts to practice. So that's what this element is. It's something that we do on behalf of these two courts. You actually sign a roll. There is a membership number, or roll number rather, which is not a membership number, but it's an indicator that to the courts that you are eligible and able to practice in Ontario in these courts. And finally, there's the attendance of the ceremony itself, which is a mandatory requirement. We do expect you to be in attendance on the day, dressed in proper court attire, to be welcomed into the profession by benchers, by representatives of the community, by your families, of course, too, and by members of the Law Society, where you receive your certificates and you are acknowledged as active and participating members of the Law Society of Ontario and lawyers within the profession in Ontario. So I think that kind of brings our session to an end, and I believe we may have a little bit of time for some questions. Are there any questions?
5 minutes for questions, so I can come around with the microphone if folks have questions. Yes.
Hello. We were talking about abridgment in article, and you told that an individual who practiced law after being graduated from a law school is can see this abridgment. And what kind of school we're talking about law jurisdiction school or common law jurisdiction?
It could be either civil or common law. As long as you've completed your law degree, that's fine.
It means that this individual was called to the bar in some country.
No, for an abridgment, you wouldn't need to be called in that jurisdiction. You would just need to have completed your law degree.
Okay, thank you.
Okay.
And Claire, I know it's hard to generalize, but typically I see abridgments 4 months, 6 months, sort of in that range. I know it's individualized.
It is individualized. It's a good rule of thumb to think that every month of experience, or every 2 months of experience is probably 1 month of an abridgment. That's a fair. But again, we look at a number of factors and calls to the bar, dates, and we try to work with the candidate.
Megan, there was one gentleman, sorry, right at the back there.
Sorry. Lots of faces to look for.
So after the exemption, I don't know whether I'm eligible for it or not. It's just for clarity. If you seek for exemption, are you completely restricted from applying from an articling position, or is that option available to you?
Well, if you've chosen to go through the process of receiving an exemption and you've completed the PCPO, then you've completed your experiential training component. If you wanted to work I mean, we do have candidates who want to work after they've been exempted. Then you can submit a supervision agreement, but you wouldn't go through the articling program. That's it's a separate program.
Yes, thank you.
Yeah.
Yeah, so any job you had wouldn't be called an articling job.
That's right.
It would be something else.
That's right.
Does the abridgment apply to only the articling position, or does it
Yes.
apply to the LPP as well?
Yes, it only applies to the articling program.
I just wanted to ask a question. If we don't know yet when we will be ready and get our NCA certificate, is there a deadline to register for the 2018-2019, or is it?
For the examinations?
Not for the for the process, for the 3-year process, to still be in the 28 to the one that's for which the application started last October.
Right, so the application that is active right now for the upcoming June, November, and March exams, so there is a deadline. We have to rein it in a little bit, but we still accept applications after the fact. There is a late fee that's applied, but if you were to apply now and indicate that you wanted to write in March, that's totally fine. We would accept it. We don't shut the doors. Well, we do have the deadlines for the examinations, so that's 30 business days, but that means that you would have had to apply before the 30 business days. But it's pretty flexible. We can work with you.
And Gina, I know one question I get a lot from NCA candidates is about the transcripts deadline.
Yes.
And the transcripts deadline, as I understand it, has no relevance to an NCA candidate because it's the deadline for submitting an NCA certificate of qualification that matters. Is that right?
The deadline to submit a CQ
Yes.
is always 30 business days before the exam.
Right.
But sometimes we have individuals that just submit the CQ,
Yes.
but nothing else. Right. And then, we want to manage their expectations so they know, what the timing is like. First, get in your application,
Yes.
and then you'll have to meet the 30 business day deadline for the CQ.
Right. But there's this one August deadline for law school transcripts, and
It's-
that's really a JD.
It's typically a JD deadline. It's very challenging to kind of put that on the website
Yes.
for our NCA candidates,
Yes.
but they normally contact us and
Yes.
clarify. So.
Okay. Any other questions? I have one question. The review that's underway right now of what the licensing process might look like in the future, realistically, are we thinking that there may be changes for 2019, 2020, or do we think we're looking beyond that for changes to the current process? I know that might be a hard question to answer.
It's hard to say, right? Because we're still very much in the consultation process. I don't expect that consultation will end until November or so of this year, and then it's a question of what convocation actually approves going forward, considering that recommendations have to be put together. And then there's an implementation process. So depending on what is implemented and how quickly it can be implemented, for example, one of the options is the current model. Right, so that's already implemented. So, if that is in fact what is selected, then really there's no change. If it's something else where there's enhancements to the current model, well, we have to look and see what those enhancements will be, how many of them can be actually implemented within the time that we're given, and then going forward. Obviously, the more radical or the more substantive the changes are, will require time for implementation.
I promise we'll be back to talk about it if something radical happens.
It's more to follow.
Yes.
More to follow.
Yeah. But as with any policy, anyone who's thinking about 2019 or beyond, the current process, may not remain as is.
So I think if you're thinking about, the prospective candidates today, that the model that exists is the model that you're entering into. Conceivably, there could be a transitional process, and again, we don't know what we're talking about, so there could be some overlap in terms of what exists now and what will exist in the future, and how we bridge the systems that are coming into place. So I think the best information that I could give you on that process is to keep your sights on that Law Society website. www.lso.ca, and watch the trends that are occurring. Participate certainly if you feel like you want to, and just be mindful of change that could be coming, and keep informed.
So our time has elapsed. I want to say thank you very much to Ken, Gina, and Claire for such an informative presentation. So we're going to take a 15-minute break. There are snacks outside, and then be back in here for 3:30.
there's a mic. Did you want a mic?
I'm sorry?
Did you?
Is there a
There's,
lapel mic?
no.
Oh, fabulous, even better. I don't think so.
Was it here?
They went home with it.
So you can either hold this guy.
Oh, I'll stand here. I'll use this one. I'll use this one, yeah.
And then I can walk around and take questions.
Sure. Use that. Yes, you probably didn't walk out when they're still wearing it.
Maybe. Can you imagine if they just started talking?
I've had that happen when I was working at here. I had to and I had it on me still. Thank God. I got on the way out, and it was like, you're on mute off, right? And I'm like, yes.
It's expensive equipment.
Yes. Then they look through labs are like $1,000, $1,500 a pop.
All right, let's get started. Hi, everyone. I think we're going to get started. So our next presentation is on the law practice program run by Ryerson University. I'm here to introduce Andre Bacchus, who is the Assistant Director of the Work Placement Office at the law practice program. Andre is responsible for working with the profession to identify work placements throughout Ontario, as well as developing and implementing the candidate preparation and support structures to ensure placements benefit both employers and candidates. In his role, Andre develops and delivers a number of professional development sessions each year to assist candidates with the application preparation, networking and outreach, in-placement success strategies, and post-placement next steps. So without further ado, here's Andre Bacchus.
Thank you so much. All right, so I understand that, first off, I'll apologize for my voice. I've got a summer cold, so forgive me if it's a bit raspy. A copy of this presentation is available on the agenda website for this conference, so make sure that you download it. That way you have a copy for yourself. What I'm going to try to do is get started with a quick overview of the program itself, and then turn it over to you for questions. I know that some of you are already registered for the current cycle, and some are wondering about the next cycle. So we'll address all those things as we come up to them. So let's just get started. I'm going to give you a quick overview of the program itself, the team, what the training looks like, a few of the things that you'll be involved with, as well as the placement part of it. As you know, the program has a 4-month training component and a 4-month placement component. We'll talk a bit about the feedback we've been getting over the last 4 years, and we're also going to discuss how you can get ready for the LPP. So let's start first off with the program itself. So some of you may be aware already, the program began as a pilot when the LSO back in 2013 came up with the idea to develop the LPP. It was slated for 3 years, and it got a 2-year extension a few years ago. So we've just completed our 4th year of the program, and we're going to be moving into year number 5 in a moment. Each year we have about 200 practitioners who work with us as part of the program, and we have a number of alliances, in particular the one with the OBA, where they help us with when it comes to outreach and education within the community. The program itself is for the profession, by the profession. This is not law school. It really is about developing your core skills and being able to get ready for success in practice. And the way that the program works, as I mentioned a second ago, is that there's a 4-month training component, and that runs from August to December. So during the training component, you're literally running a virtual law firm. 4 of you, along with a practicing member of the bar, are working together in 7 areas of law to do about 120 different tasks. And by doing these tasks, you're developing those core skills. It's then followed by a 4-month work placement, but you must successfully complete the 4-month training to get to your work placement. You can get hired in a placement, but you may not be able to start if you don't complete successfully the training piece. And I'll get to that in a moment. The team that runs the program, I'm one member of the 4-person group that started it. Chris Bentley, the former Attorney General for our province, is my boss. Gina Alexandris is the Senior Program Director responsible for training. I'm responsible for the work placement side of things, and Abner Levin, our academic director. We also have a pretty sizable team supporting us to ensure that you get the support that you need as part of the program. And again, we have the community, the practitioners, the lawyers, who are part of our profession, supporting us and helping to train each of you and evaluate what you're doing. So it really is about getting you ready, not just to be called to the bar, but to find success afterward in your practice, because that's just the beginning of when things start for you. Once you're called, your career then begins and you can move on, but you need to have the tools to do that. So how do we equip you with those tools? Well, first off, during the training component that I mentioned from August to December, during this entire 4-month time, it's run as a virtual practice. So you are busy from 8 to 6, Monday through Friday, sometimes on weekends, sometimes on evenings when things come up, just like they do in real life in practice. And we encourage you to appreciate that this isn't law school. There's no syllabus to say, here's how your week is going to unfold. Here's what's going to happen 2 weeks from now. We don't know that in real life. The phone rings, a client walks in, a judge does this, someone does that, and we have to react to it. And that's exactly what you'll be doing, is reacting to it and learning by doing it. I mentioned the virtual law firm, there'll be 4 of you and a practicing member of the bar. So we have lawyers who sign up with us to act as mentors or senior partners, and they will meet with you each week, whether in person or via WebEx online, to discuss who's tackling this part of the file, who's drafting this, who's doing that, and to also give you feedback on the work that you're doing. There are a lot of things that you need to be mindful of when you're in the training component, that it is going to be full-time commitment, that it's going to require you to be able to adapt and move as things evolve, and that you're also going to be required to produce items on a timeline. Meaning, if your partner says they need this by 4 o'clock on this day, it's got to arrive at 4 o'clock on this day. Ultimately, they're going to then need it to file with someone else or do what they need to do to advise the client. So it's all strictly operated, and the deadlines are the deadlines. So if you have an issue or a concern or something that comes up, as it does in real life, you need to talk to our team. And our team is there to support you, but you got to talk to them. Otherwise, you know, you just don't get counted for that assignment if that's going to be the situation that you don't hand it in. The training component then, it lays out like this. It's really simple and straightforward when you look at it this way. 7 areas of law, core skills, and really all about you acquiring those skills by doing things. We have 3 in-person weeks that are required for you to be on our campus downtown. 1 at the beginning, that's in August, 1 in the middle of October, and 1 at the end, which is in December. During those in-person weeks, we're going to have a number of folks around you assessing what you're doing, looking at how you interview your clients, how you argue your motion, how you conduct your research, all the types of things that you would be doing in practice, and giving you feedback on that. And those assessments get fed into your overall results for the training component. So it's critical that you appreciate that those 3 in-person weeks are there, and they're mandatory, there's no exception. Outside of those 3 in-person weeks, though, you're going to be working from your home office, wherever that might be. So if it's in your bedroom, if it's in your basement, if it's at a coffee shop or somewhere else, that's okay. But you got to be in business attire. You've got to be ready, because it's all live online, that if you have a client meeting at 10 a.m., you're talking to your client on the screen and they're interviewing you, and someone else is watching that happen and they're assessing you on that performance. At the same time as well, you're going to be meeting with your team members. So one of you could be here in North Toronto, someone else is downtown, someone else is in London, maybe another candidate's in Ottawa, and your mentor happens to be in downtown Toronto. All 5 of you will see each other on the screen to discuss your matters as if you were sitting in the same meeting room. So again, you've got to look the part, you've got to be ready to go, and no one's rescheduling these meetings. They're happening. And you'll be told when they're going to happen, and they run with it. And sometimes emergencies happen, and all of a sudden you find out that the judge who is going to hear your motion is no longer available, and it's not happening on Thursday anymore, it's happening on Monday morning, and you've got to work all weekend and deal with it. Or your client calls you on Friday night, and they're in jail, and you've got to respond, and you do. It's all happening again in real time. So this requires your commitment that it's a real-time program. It's not a video you can watch at midnight on your own. It's not that you work by yourself. You work as part of a team. And working as part of a team, one of the core skills that you're going to need in practice, whether you have, you're in a sole practice with just your assistant, or you're in a 1,000-person firm, or you're working with the other side, or dealing with something else. Those skills are absolutely critical. So these are the types of things that we want to impart to you as part of the program to ensure that you will develop the skills to be able to get to your ultimate goal of being successful in practice. Over the course of the training component, there are a number of areas of law that you'll be touching on. Now, we're not going to substantively train you in each of these areas, but you will have files in each of them. So there'll be foundational sessions that will help you to get your grounding. There'll be resources for you to draw on from our internal intranet, our company or firm intranet that you can leverage for precedents, for secondary material, for other material that you'll need. But it'll be up to you, as you would in practice, get up to speed to get the job done. No one's going to hold your hand and say, here's the step you take, here's what you're going to do, here's what you're going to do next. No one does that in practice for you either. You're going to be on your own with your team, with your firm, with your supervising lawyer, determining how you tackle each of these files. And they're not happening sequentially. They're happening simultaneously. That means you have to juggle competing priorities, you have to juggle different areas of law, and that's just the nature of practice. Again, it's to force you to develop the skills you're going to need to be successful once you're called. So it's all designed, again, to simulate as close as possible real life. And that'll give you the chance to be able to ultimately succeed in your placement and ultimately succeed once you're called. So here are the 100+ tasks, that just a taste of some of them that you'll be involved with. When we started this presentation back 4 years ago, I had 70+ up there. And by November, folks started to poke at me and say, hey, by the way, we're well past 70, we're into 75, and we've still got 4 more weeks of this to go. So it's not really 70, it's more like 100+. I said, you're right, it is 100+. We just don't want to scare you in the first year. But now we're telling you, it is 100+. And be ready for that. And there's a reason. It really allows you to develop the skills. So you're going to draft things, you're going to interview your clients, and you're like, who are these clients that I'm interviewing? Well, we have an interpersonal skills teaching center on campus that trains actors to play the clients. Those actors are with you throughout the course of the training component, and they are going to be your client that you interview. They will behave the way clients will behave. They will get emotional. They'll be upset. They will refuse to pay the bill. They will do all the things that clients typically tend to do. And you'll have to roll with it and deal with it. And someone is assessing on how you manage that. And we know your first interview may not be perfect, and that's totally fine. But by your third, your fourth, your fifth, you'll be that much better. So that when you get to your placement, you're ready to hit the ground running, but also when you're in practice on your own or somewhere else, you can really do the job well. And that's the goal here, is to get you ready for that. So in addition to the skills and the tasks that I just mentioned, these are a few things that we offer as part of the LPP that help us to deliver a robust program that allow you to develop the skills. So yes, WebEx, so if you're not familiar with technology and you don't use it often, I encourage you, get used to it. Tech is a big part of our practice and our profession now, more so than ever, and it's a big part of our program. So become very comfortable with it. You'll use the tools that everyone uses in practice, Westlaw and QuickLaw. You'll be using a duplicate of TerraNet and TerraView, the database that real estate lawyers use for transactions. So we have the only copy of that database. We worked out a partnership where you actually will do a closing so that you will simulate what happens in real life. You'll also get intensive trial advocacy training by the leaders in the profession who do this on a paid basis globally for judges and lawyers around the world. That's part of our program. And they will spend 3 days with you as part of the in-person weeks, helping you on that front. Stitfeld Handy as well when it comes to negotiation. A number of other programs through other organizations, as well as the Corporate Counsel Intensive. 30% of our work placements are in-house legal departments here in Ontario. And these in-house departments previously wouldn't hire law students to work for them or to article for them, simply because they didn't have the resources to train them or the time, and really they couldn't justify having someone there for 10 months. But they can partner with us for 4 months. And funny enough, some of those 4-month placements turn out to be full-time opportunities afterward because they realize what a benefit it is to have someone on board. So we make sure that you get their insights as part of your training so you know what they're looking for and what to be ready with when you get to their site. Ultimately, all the things that we're doing are really geared towards enhancing and developing your skills. A few other extras that we do as well, an Access to Justice Challenge. We're going to present you with a problem, whether it's a domestic or international problem, and as your groups, you're going to work out a way of dealing with that. You'll all make a submission of how to deal with that using tech or other ways of doing things. And then the top 7 teams will then pitch Dragon's Den style to leaders in our profession about their particular solution. And the winners of that contest end up having lunch with the Chief Justice of Ontario. So it really is an opportunity for you to shine, develop your skills, and at the same time, push yourself to think about how we can make our profession better and have it address the problems that aren't being addressed. You're also going to put together a business plan. Many of you haven't even thought of what a business plan looks like or may have even appreciated what it's about. But you're going to do that. RBC, our partner, along with the former General Counsel for Imperial Oil, will help you to understand financial statements, help you to appreciate what you need to do, and think about it as part of developing that skill set. Because when you're in practice, whether you're on your own or in government or in-house or somewhere else, you've got to balance the books that you're dealing with. You have to run your business. And if you can't do that, all the knowledge in the law won't help you. If you don't have clients and you can't pay your way. So this will help you, help to put you on the right path by doing this. The placements then. So what happens after you complete successfully the training component? So if you're successful in completing the training component, you will then move into your 4-month work placement. And the idea behind the placement is not that you're going to get exposed to everything under the sun. We know that even in the best articling situation of 10 months, you can't get exposed to everything because you're doing the work that comes in the door. So what we ask you and the lawyer that you're working with in your placement to do is to just naturally integrate you into their practice so that you can further refine some of the core skills you gained as part of the training component. That way, you're just further getting a chance to get better at what you're doing and also see someone else in practice and get a chance to appreciate what they're about. We tell our employers, and we tell them, this is our pitch to the employers who hire our candidates. We tell them you're going to hit the ground running. So when I'm on the phone or my coordinators are on the phone or anyone else on the team is talking to a prospective employer, we're telling them that you're going to be ready to get involved, ready to do the job, ready to help out on day one. And the only way that we can say that is if we know we're preparing you for that. But rest assured, if you arrive and you're not doing a great job, we're going to hear about it from them. So please do yourself a favor, put in the work, do the things that you need to do to develop the skills so when you get there, you can hit the ground running. In the last 4 years, all eligible candidates received a work placement. So we had a 100% placement rate in years 1, 2, 3, and 4. So that's about 220 candidates each year in our program. And that's a combination of you doing your part in conducting outreach and also applying to the positions that we post. It's critical, though, that you understand what you are applying with. Your cover letter and your resume are your samples for that employer. They're writing samples. That's all they have to judge you by. And if you're not putting a good effort into this, it will harm you in the process of being selected by them for a potential opportunity. So as I mentioned, there are 2 ways to get a placement. You can bring it to us, and we'll review it and make sure that it meets the criteria. And if it is, I'll sign off on it. And also applying to the positions that we post. The majority of candidates do get their roles from our positions that we post. That's true. But a number do bring new employers to us as well. And if they've done a great job, that employer may come back in the following year to the program as well. So I encourage you, build those networking skills, do your outreach. These are all things that will serve you well in practice down the road when you're trying to procure clients, develop a network to service others, or find your next opportunity. So networking is going to be critical as part of this. The placement process then, basically, you apply to the roles that we post. The employer has the final decision. I don't get to decide. So no matter how much you may come to my office and say, I really want this job at RBC or at BMO or somewhere else, I don't have any influence. They're going to judge you on your material, and they're going to judge you on your performance in the interview. And then when you get there, they're going to judge you on the work that you do. And then they'll report that back to us. So it's critical that you appreciate that. Throughout the year, we host a number of PD sessions. So for those of you who've already signed up for this current cycle, year number 5, on June 14th, I'll be doing PD session number 1 with you, getting ready, getting your material ready, getting yourselves ready for the first round of jobs that get posted on July 3rd. And they're open until July 9th. Then we process them and they go off to the employers and they interview you in August. So some of you may end up landing a job before you even start the program. That's great. It's one less thing to worry about. But the majority of you will still be looking. And you've got to be able to balance that effectively during the training component to make sure that you can get things done. So I encourage you to allocate your time wisely, pay attention to the material that we send out to you, follow the instructions, and seek help when you need help. Don't wait for the last minute. We have employees from all sectors working with us over these last 4 years. And we anticipate that we'll have the same type of breakdown again this coming year. I have no way, though, of guaranteeing who the employers are going to be in each given year. It changes every year. If an employer hires someone full-time from their placement, they have no more room, they may not come back. And that's fine. That's great for that person. We'll find somebody else to replace them. So each year, as the positions go up, you'll see, as I see as well. So private practice, in-house, government, and clinics. Those are the main areas. This is just a sample of some of the employers we've had over the last little while. Some of these come back each year, some don't. It all depends, right? There are a lot of factors that determine when an employer decides to sign on board. And of course, we thank all of our employees every year. A list of our employers from each of the 4 years is available on our website in the thank you ads. It's important that you know that because I want you to look at those ads. I want you to look at them so you know who the employers are, but I also want you to look at them to appreciate that you are not calling those employers to ask for a job. That's our job. We've already procured those employers. They're with us. We follow up with them. They don't want to hear 220 people calling them, can you bring me on board for a placement, right? So it's important that you look at that list carefully. There are 4 lists. You look at them. If you're planning to do outreach and you determine if your employer is on there. If they're on there, you can't reach out. If they're not on there, by all means, go right ahead. And we have a whole kit and package available for you to be able to send to that employer, along with even a draft email that'll help you look as professional as you can be. So you'll get all that as we go through. So these are what the lists look like. I encourage you to read them. It's tiny print, but do read them. It will be helpful. And we'll work with you and explain this a bit more during the PD session when I'm there. Some of our employers have already provided us quotes over the years. We've taken out various ads to help encourage other employers to see what the feedback has been like. I encourage you to take a look at that as well. Your performance or the performance of previous candidates really shape how our program evolves. So if an employer has a bad experience, they may not want to come back. So it's not just your reputation that gets harmed, it's the program and also future candidates who want to get opportunities. So I encourage everyone to do their best, and we're here to support you in doing that. So together, we can make it work. Some other feedback from employers, and it's really amazing when we get this feedback because it really tells us that we're helping you develop those skills and that you're showing them. And when you show them really well, and if the employer has money and they can create a full-time role, well, you're probably going to create a job for yourself that you never thought you might have. We have candidates who've come back to us to say, but for the program, they would never have landed where they landed. And that's great to hear because we're happy to open doors, happy to help you out, but you got to do the work. Candidate feedback as well. So candidates also give us their feedback. Inevitably, in those first 4 weeks of January, We get phone calls and emails from folks saying, now I know why you had us do this or do this, because I'm actually doing it right now on the job and I know what to do. And that's great. That's wonderful. We want you to be in that position of having confidence and having that ability. But again, you got to do the work to be there. And when I say do the work too, there are online things that you have to watch and do. I'm not going to be over your shoulder, and no one else will be, to make sure that you do it. You've got to do it to get the job done and to get the knowledge. So we can find out if you haven't watched the material, and we will sometimes poke at you if we're not seeing you doing it. But it's important that you do. It's for your benefit. So getting ready for the LPP, these are the things that you really, really want to make sure are in good shape, or at least you've worked on. So if your legal research and writing skills need a bit of brushing up, you haven't done a heck of a lot of this, I encourage you, go to the online resources that are available and use them to help you. We provided, for those of you who've signed up already, links to some of the resources that can help you out. It's in that manual that was sent to you, that book on how to succeed. Turn to the page and use the material. Comm skills, same thing. Absolutely critical and essential. You will be judged on those. Time management skills, of course, there'll be things to juggle. Your personal life, the work, unexpected things, but you've got to roll with it. It happens in practice as well. Tech skills, critical. So if you need to bone up on those, I encourage you, go to the online resources and use them. Your cover letter and resume, you should be working on them right now already and have them put together as best as you can. And then in PD1, I will tell you a bit more about how you can refine them. But we've also given you links in the manual we've sent you already. So use those links to help you refine your material further before you get to us. And of course, your professional presence. Check yourself online. Make sure there's nothing out there that's going to cause a problem. Our employers will Google you. The other side will Google you. Your future clients will Google you. Your colleagues will Google you. And whatever they find will color how they, assess you and determine if they want you on their team. So it's important that you make sure that this stuff is all put together well and that you manage it. So I encourage you, spend the time now that you have it to go over all of this. Important dates, well, tomorrow's the deadline. So if you haven't elected us now, you have up until tomorrow to do that, June 1st. So if you're wondering, stop wondering, log into the portal and check the box off. So that way you're on our list. If you are not on our list by June 1st, you won't be with us in the program. Okay, that's just the way it works. We've got to be able to plan and roll things out right away. So immediately on June 1st, once we have that list and that information, we then get all of your material together, send out to you a set of links for you to register officially in the program, leverage the resources, and then get you ready for the first set of jobs that get posted and get you ready for some of the assignments that you will receive over the summer too. There are a couple of things we need you to do over the summer, and we need you to get them ready for that first in-person week. So make sure that you're signed up with us. These are the mandatory in-person weeks, as I mentioned. Here are the dates for them. And then, of course, the work placement window of January to April 2019. Some of you are already thinking, wow, you're already talking about January 2019. I've got employers who already have their material into us for January 2019, who want to get their job posted, who want to interview in August, who want to get the process done with before the fall rolls around. So people plan that far ahead. So it's important that you start thinking that way as well. The quicker we get all this together and done, the better it is for all of you and for us. We want all of you to succeed. That's the ultimate goal here. It's your success. But we can only do it together as partners in doing that. So the LPP candidates over the last 4 years, here's what the group looks like. We're in year 4 right now. And yes, I think I wear the gray suit a bit too often. I noticed that in 3 of these photos, I have the gray suit on all the time. My colleagues keep nudging me about that. So we're black for you today. And ultimately, of course, I'm happy to answer any questions that you have. I encourage you to download this presentation, go to our website. There are a number of videos under the For Candidates section that will help you hear from previous candidates, help you hear from employers to appreciate what this is all about. so that you can be as well informed as you need to be for your own success. So I encourage you to do that. Now, happy to take any questions. Sure.
For questions. Okay. Coming around.
Hi. My question is, how practical is this program if you're writing the bar exam in November or March?
Very good question. I'm glad that you asked. We strongly encourage all of our candidates to write the exams in June because you're extremely busy in the fall, and there's no guarantee during March in your placement the employer will even give you the day off to write the exam. They don't have to. You're in a 4-month placement, so it's not required. So, and if something were to blow up in their practice and they need you there, they need you there. It's someone's real life matter that's being dealt with. So as much as possible, get it done this June. If you haven't, maybe you could get one done in the fall and then do the second one after your placement. And we have a number of candidates who delay their exams till the following June because they recognize that they just don't have the time. So it's a fair question. The best answer I can say is get it done before or after the program if you want to do yourself a favor, because you are juggling a lot. Yep. Other questions? Be straight up, ask away. No question is silly. Everyone, I'm sure others are thinking about it.
I have a question, Andre.
Of course, yes.
2019 or beyond, we heard from the
Right.
Law Society. We know that the LPP was extended up until this year.
Right, so year number 5, so 2018,
That's right.
2019.
So are we
looking at year 6,
Yeah,
year
so
7, year 8.
Are we waiting for a final confirmation
So-
for future years?
The way the licensing process has unfolded over the last little bit, the Law Society has just released 2 convocation, the 4 options that they're suggesting that we have discussions around. So the profession and would-be members of the profession, yourselves, are all part of that process. So they have a comment deadline of October 26th. I strongly encourage all of you, if you want to see a year 6 of this and you want to be able to take advantage of it, make your comments known. The Law Society will then take all those comments in. They will then digest them as part of their PD&C committee. That committee will then issue a recommendation in the spring of 2019 as to what's going to happen for the 6th year of the program. So not a lot of lead up for us. We're going to operate under the idea that we have to be ready for anything. I encourage all of you, though, to make your voices heard, because if you want to have this option available, you want to make sure that people know that that's what you want and why you want it. And we have had close to 900 folks come through this program in just the last 4 years. And it's created 900 placements that didn't exist before and jobs that wouldn't have existed before. So it would be really sad not to see it around, not because it's my work, but because of what we've been able to do in the community and what we've been able to shape within our profession. So it's up to all of you to also make your voices heard on that front.
And there will be a couple of candidates on our panels later today who've been through the LPP, and some people at the reception tonight that you can network with if you want to ask some questions.
Absolutely. Other questions? Nobody?
Here we go.
Yep.
Let's just
Yep,
take
one more.
I think we've got one back here, and then we'll
Yep.
wrap up.
I just wanted to know what percentage of your candidates are internationally trained lawyers?
Very fair question. Wonderful. So basically each year, and we don't have any control over this, so it's not that I can actually make this number up, but approximately 50% of our candidates in the program each year graduated from a Canadian law school, from BC to Nova Scotia. And the other half of the candidate pool are folks who went to study abroad in the UK, the US, or Australia. And of that group, the majority did their undergrad here in Ontario and then went abroad to study. And some are new lawyers who are emigrating from their homeland, coming here now to Ontario to make a new life. So that's the breakdown.
Okay.
And if anyone's wondering how you get your virtual firm put together, you don't get to pick your friends if your friends are in the program. The computer randomly assigns you to the firms. So please don't call us up and say, 3 of us are friends, we're in this, can we be? No, it won't happen that way. It'll be randomly assigned. Wonderful. Well, thank you all so much for your time. I really appreciate it. Check out the website. Look at the presentation again if you need to. Other questions, email us or give us a call. Thanks so much.
Thank you so much, Andre. Okay, so we're going to go right into our next presentation without a break. And we will have a break after this next one.
And Megan and I are
Yes.
classmates here at Osgoode.
We went to Osgoode together.
Yeah.
Thank you.
Yeah.
And Andre used to work here
True.
in student services. So whenever Andre comes back, it's kind of like a welcome home, which is great. Thank you.